I'm Drew Stevenson, and this is a lecture about the case Motor Vehicle Manufacturers Association versus State Farm Mutual Auto Insurance Company, a very famous U.S. Supreme Court case from 1983, and that we have come to associate with something called hard look review in administrative law and the law of judicial deference to agencies. And so now this is a very famous case in administrative law. And here the agency loses. The court purports to be applying arbitrary and capricious standards under Administrative Procedure Act 706A2, but it does so in a way that uses a lot of scrutiny. It doesn't seem very deferential, and the agency loses. For my students, you should connect this case in your mind with the Overton Park decision, where the court does something sort of similar. And so those two cases together are what we really associate with hard look review, and that's your big takeaway from the case. So let's talk about what happened. Here's our statute. The National Traffic and Motor Vehicle Safety Act directs the Department or Secretary of Transportation to issue motor vehicle safety standards. And so throughout this video and the case, it talks about the secretary, but honestly, this really came from personnel in the department. So the DOT is supposed to consider relevant safety data and whether the proposed standards are reasonable, practicable, that means affordable, and appropriate, and also how much the rule furthers the Act's purposes. Now, this went through a lengthy internal process, and before we get to 1978, the middle of the Carter era, when the Secretary of Transportation promulgated a rule requiring that by 1984, all cars had to have a passive restraint system, and that meant car makers could make cars either with airbags or automatic seatbelts, not the traditional seatbelt like you might find on an airplane where you buckle yourself in, but something that mechanically wraps around you when you turn the car on and wraps you in a shoulder belt. Now, as an aside for my students, there's something interesting in the background here about the way regulation works and sort of the politics of it and the dynamics of it in practice. So we originally get this statute in the late 60s because cars were not safe and Americans were dying on the highways in rather shocking numbers, and including a lot of young people were dying. And so the people were talking about things like car accidents are killing more people than the Vietnam War and so forth. So the public demanded that Congress save us from ourselves, right? That make cars safer. And so Congress passes this statute and directs the Department of Transportation to require some way of making them safer. And so the first idea, cars already had manual seatbelts, kind of old-fashioned seatbelts in them, but Americans wouldn't buckle them. And so they want to jump in and out of their car like Batman. And so then they get in an accident. There was a seatbelt there that they weren't using. And so, they call their congressman and say, you need to save me from myself. I don't want to wear my seatbelt, but I need to wear my seatbelt. So make the car makers somehow make me be belted in so I don't get hurt when I get in an accident, but I also don't have to do the small step of buckling my seatbelt. I'm telling this story, I hope my students maybe even connect it to wearing masks in pandemics and all other sorts of safety regulations, right? So we also have regulations that lawnmowers are supposed to have a safety mechanism on the grip because they're mowing the lawn and something gets stuck in the blade knocking around down there, and people have this irresistible urge to stick their hand in the business end of the lawnmower and try to pull whatever it is out, and it cuts their fingers off. And so again, there's pressure, and the regulatory agencies require, okay, if you let go of the handle of the lawnmower, it's an engine, it cuts out the engine, so the blade stops instantly. Well, that's supposed to save your fingers, and so that you don't, when you stick your hand in the lawnmower while it's running, you will let go of the lawnmower handle and it will stop the blade instantly. But people don't like that because they want to be able to take their hands off the lawnmower for a second and get a drink or talk to their friend or something. So people duct tape the handle together so that they can still cut their fingers off while they're mowing the lawn. And Americans are kind of like this about seatbelts too. So the first attempt was to have an ignition lock. And there's a couple years of model cars where you couldn't turn the car on unless your seatbelt was buckled. This was wildly unpopular, right? So Congress kind of demanded that the agency try a different rule. So then we get a year or two model cars where a very unpleasant alarm blares at you the entire time you're driving the car until the seatbelts are buckled. And I don't mean the nice little like new age chime that your car politely makes at you now today when you don't buckle your seatbelt and it gives up after about 3 chimes. This would blare loudly and unbearably the entire time for 100 miles if you didn't buckle your seatbelt. And so that also was very unpopular. And that brings us to the rule in 1978 that just said, okay, car makers, take a pick. Americans don't want to go through their windshields when they get in an accident, and they also absolutely refuse to buckle the seatbelt themselves. So you either need to have a robot buckle them in or have an airbag that explodes in their face and keeps them from going through the windshield. And that's where we get the rule in 1978. So far, so good. Now, an earlier version of the rule, they thought they maybe should just require airbags. Let's just forget seatbelts and just go with airbags. But the auto industry didn't want to do that because they thought Americans wouldn't want to pay for airbags and wouldn't like them. And so they had lobbied for the option to comply with with using automatic seatbelts that kind of wrap around you instead when you turn the car on. And so the agency had produced several studies showing that passive restraints would save thousands of lives. And that rule of requiring either seatbelts or airbags was challenged in court, and the courts had upheld it. Notice here who our parties are. Our parties are the insurance industry. They have to pay the bills when people get hurt in car accidents, and versus the car makers who basically don't want to put safety features in the car because it makes it a little more expensive, and they want to make the cars as cheap as possible so that more people will buy them. Well, let's roll in Ronald Reagan. In 1980, he wins the presidency and appoints a new Secretary of Transportation who within a year reopens the rulemaking, does a notice and comment period, and then rescinds the rule entirely, which is exactly what this is like the auto manufacturer's dream, right? So, wow, we don't have to do anything now. And the agency, the secretary, offered 3 reasons. It said, first, this is going to be this is a costly for the auto industry, and the poor auto industry is having a hard time in the 1980s. And so let's give them a break and not have them have to install these fancy automatic seatbelts or airbags. Secondly, we think everybody is going to just use these passive seatbelts, but they're detachable. Customers can just remove them with a screwdriver, right? And take them out. And so the third step is they're not going to save anybody because we think drivers are going to get annoyed that they're buckled in. People don't want to be buckled in their cars, but they also never want to get hurt. And so they want we as a people, we want contradictory things. Keep us from getting hurt and don't make us ever feel constrained or restrained or anything like that. And so they said, we don't have evidence that people won't detach the belt, so therefore we're not sure we'll achieve the safety benefits. And therefore, there's going to be huge compliance costs on the industry. So this decision to rescind the rule provoked another legal challenge. And the main argument was that this was arbitrary and capricious under the Administrative Procedure Act 706(2)(a). Now, notice here in the case what the different players are arguing. So notice what the agency argued, and then what the challengers asserted, and then what the court held. This can be kind of convoluted. So the agency believed that 99% of the car makers were going to comply with the regulation by installing a detachable automatic seatbelt. And again, this is something that automatically wraps around the driver and the person in the passenger seat when you turn the car on as a shoulder belt. But they said that there was no evidence that this would save lives because people could remove them, right? All you really need is a pair of tough scissors or a screwdriver or knowing how to undo the certain special latches. So therefore, they didn't think there were going to be all that many benefits, and the costs would therefore outweigh the benefits. State Farm, who has to pay the bills when people get hurt, argued that even if the agency's concerns were valid, right, that they were concerned too that people were going to just remove the seatbelts so that they wouldn't be buckled in, they thought the obvious alternative was just to require airbags in all the cars, which of course is what we do today. The agency offered no real explanation as to why it didn't even consider an airbags only alternative, and this really bothered the court. So we have kind of two holdings from the court. They unanimously accepted the argument by the first argument from State Farm, ruling that the agency had acted arbitrarily and capriciously in this regard, that it didn't really consider a very obvious alternative of just requiring airbags. But State Farm had another argument. They also said the agency had acted arbitrarily in concluding that detachable seatbelts wouldn't save any more lives. They wanted to win that point too, because they said some seatbelts are better than nothing. And why? This was the idea of inertia. They said if the seatbelt's there, um, a lot of people aren't going to bother, right? If Americans can't bother buckling their seatbelt, who's going to get a screwdriver or the tool to detach the seatbelt when it's there? A lot of people are just going to let it buckle them in, they said, and so that would save lives. And the agency had recognized the inertia issue when it included automatic seatbelts in its initial rule. So the agency believed this and then contradicted it when they rescinded the rule. So the court not everyone on the court was convinced by this. And so the majority still agreed with State Farm about this, but this part of the decision was only 5-4. I know this is a little confusing when you're reading the opinion. So here's a highlight from the opinion, though. This is the hard look doctrine part that really matters for administrative law. And this quote, by the way, to this day is the classic formulation of the standard of review, of hard look review. An agency must examine the relevant data and articulate a satisfactory explanation for its action, including a rational connection between the facts found and the choice made. So if there was one line that you're going to pull out of the case, that should be it. So what are we left with then for hard look review? And we're basically going to say an agency's actions are arbitrary and capricious if they relied on factors that Congress would not have intended the agency to consider, or they entirely failed to consider an important aspect of the problem, or an important alternative to their rule, an easier alternative, or they offer an explanation for the decision that contradicts the evidence before it, right? And all of these are kind of going on in this case. Now, we do have a dissent from Justice Rehnquist that's kind of a political argument, right? He says, look, Reagan won, elections have consequences, and the election of a new president with a different regulatory philosophy supplies an important and legitimate reason for the agency's changed view on the desirability of the passive restraints rule. In other words, we had a presidential election. One of the candidates campaigned explicitly on a deregulation platform. He said he was going to deregulate, and he won in a landslide. So Rehnquist says that's a voter mandate and that the agency has a right to consider, and that's kind of built into our appointments clause, right? If the new president is getting to appoint the head of a new Secretary of Transportation, then that implies that that person is going to implement the president's philosophy, and that's why we have elections. People can, when can vote out an unpopular president or unpopular policies and vote in someone that will do what they want. Section 706(2)(a) was supposed to be a deferential standard of review. And although there's a substantive element to hard look review, the emphasis is usually honestly on the reasonableness of the agency's analysis and its explanation. Courts look to how the agency handled feedback and criticism during the notice and comment period, what sort of evidence it points to as in the record for its conclusions, and whether the agency explained, articulated its choice adequately. And that is really spelled out in the Overton Park case. And then whether this explanation is plausible. And in this case, the court really doesn't find the agency's explanation plausible. Please note that in practice, when we're talking about the hard look review, it's probably hard for courts to separate the adequacy of an agency's reasoning from the court's own beliefs about whether the ultimate conclusion makes sense. In other words, a lot of us think that what we're doing, the more scrutiny we apply to the agency's reasons, the more the court can inject its own policy preferences and opinions and biases into how it views how convinced it is by what the agency says. It's often hard to tell how much reasoning a court will demand or what it will think is important. So we're wrapping up here our discussion about the State Farm case. By the way, this was a big blow to the Department of Transportation. And since then, they kind of backed off to a large extent on regulating cars through notice and comment rulemaking, and instead regulate primarily through recalls. And so the car makers, the industry gets to innovate and put in safety features, market their safety features. And then when something goes wrong, they're ordered to do recalls. And that's why if you've bought a car, you probably get recall notices. That's actually our regulatory technique that's sort of the legacy of the State Farm decision. And that concludes our lecture for now about State Farm.